Welcome to the Case Autopsy, the Verdict and Settlement podcast with your host, Mike Campbell. Case Autopsy is part of the family of podcasts brought to you by Lawyer Minds. In this podcast, we explore recent verdicts and settlements from around the country to try and distill down the best techniques for you to apply in your cases. Here's your hosts, Mike Campbell and Chris Finney.
Chris, what's going on, brother?
Not much. How you doing, Mike?
Good, man. We've been busy.
Yeah, it's things are ramping up, and then hopefully they keep going. Hopefully we keep the pace going.
Yeah, I mean, I know that you and I would love to sit down every week and talk with someone and share everything that we learn with everyone else, but we're active trial lawyers, and that's just not going to happen.
It's not, but when we get opportunities like talking to Rob, you got to take them because it's for us. It's pure. I mean, for me, it's purely selfish. He's
a gem.
I think this one's going to be pretty good. He is an elite lawyer in Pennsylvania, so I think this is going to be. I'm going to learn a lot. Hopefully, everybody else does.
All right, man. Well, let's get at it.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. Here's your hosts, Mike Campbell and Chris Finney.
Rob, how's it going, brother?
It's going really well, Mike. It's great to see you, even though it's by Zoom. It's been too long, actually.
So your trip, I want to say, was the last trip that I made out of state before the world shut down.
Absolutely. And, on the trip where you guys came in and were filming at my firm, part of the footage we shot was down at my boathouse with me going down on the river. You remember, it was late February and it started to snow right when I was dropping the boat into the river. And it turns out that was my last row before the world shut down until, oh goodness, April of this year. So that was 14 months. I haven't been off the water in 14 months since I can't remember.
And rowing is a big part of who you are. I mean, that was a part of what we tried to capture in those videos too.
Yeah, I was out 4 mornings last week, and actually one of the times I did a double trip because there was a friend who just is rehabbing from shoulder surgery. So I did my regular row at 5:15 in the morning, and at 6:30 when we put that boat away, I took out another boat with a friend who's rehabbing his shoulder and did another trip up the river. So I actually had 5 rows last week in 4 days.
So that, God bless that. So besides rowing, you also do a little trial law. Is that right?
In my spare time, I try to. Yeah, exactly.
That's right. Yeah. What kind of cases do you handle?
So I've been an attorney for 37 years, and the bulk of my practice is medical malpractice and nursing home. And I also have about 10%, pretty consistently over the years, 10% is other complex personal injury cases. I do a lot of commercial vehicle work and some product liability work, but by and large, it's anything. I like to tell my clients anything where there's going to be a big stack of medical records and there are going to be a lot of experts involved in the case. Those are the cases I love to wade into.
And so, I would encourage anyone listening to this, go watch some of these client testimonials. They're so powerful. Rob has handled a number of medical malpractice cases in the greater Pennsylvania area. And so the case we want to discuss today, though, is kind of just dive in and dissect was, I believe, one of these complicated personal injury cases, right? And that falls in that 10%.
Exactly. And actually, believe it or not, I can't explain the connection too closely, but the case involved an 86-year-old woman who was as vital as you can possibly imagine. She still did extraordinary charitable fundraising work for one of the big hospitals here in Philadelphia. And as it turns out, my rowing partner in a double trained under her late husband. So it's just amazing, the connections in a city like Philadelphia where somebody always knows somebody. But it was a case where she had actually just been in meeting with the head of the hospital about an upcoming fundraiser thing. She left that doctor's office, walked a block, and as she was crossing the street on one of the main streets in Philadelphia, Walnut Street, at the intersection, she had a green light. She was in the crosswalk, and a vehicle coming the other way on Walnut Street made a left turn right in front of her and didn't see her and just knocked her down. And then in the crush of hysteria, a crowd of people who responded yelling at him to stop, stop, stop. He then 7 seconds later backed up over her again. The really impressive thing from my perspective, when I first heard about this from her family, she spent 42 days in the hospital. So I was contacted by her adult children first, but the most impressive thing to me was she never lost consciousness. And it was, she remembered everything. So I got involved initially with the children as the primary contact, but as she over time recovered, my contacts really became more and more directly with
Rob.
with her.
How soon did you get that file? Were you contacted on that file? Because I'm thinking there's a lot of people, there's maybe a lot of witnesses, and as a lot of us deal with cases like these, if you don't get to them fast, things disappear. If there's video, it disappears. Eyewitnesses who aren't necessarily in the report disappear. You really relying on police officers to do a lot of the work if you don't get it right off the bat. So when did you get that file?
So Chris, I was contacted probably within the first week. This was a woman who actually had significant assets, and I was contacted by her estates and trusts, family estates and trust attorney. And I've worked with that firm over the years, and I got the call and I said, I'd be happy to talk to them, and said, please encourage them. Don't shop this case around. There are things that must happen immediately. Most significantly, if there's video to be found, I really need to get somebody out there to canvass the scene. I spoke with the family, and through the wonder of email and everything, I was retained very quickly. And the very first thing I did was hire a wonderful PI that I work with on a lot of cases, and I explained where the intersection was, and sent the PI out to essentially go from business to business, see who had video. Turns out one of the buildings was a medical office building, and although they didn't have external video, they had a camera shot from their lobby, a security video in their lobby that showed the whole intersection. And I wrote to general counsel for that hospital system. It's somebody I've interacted with on other.
Yeah, I was going to say, so you're contacting a general counsel for a hospital system. You've probably handled in an adversarial position many times in the past, and you're asking, hey, I need you to preserve this for me.
That letter started out with, this case does not involve your institution.
Yeah.
But I in the event you have video that captured these events, I would respectfully request that be preserved. Not only did I know him, he's actually somebody who went to college with me in Massachusetts and was my fraternity brother. So I was able to get that very quickly. And not only did it show her being hit, it showed her, so picture the corner of the building, it showed her walking down Walnut Street. Then there was a central pillar in the building, and then the other glass side, you could see her get to the curb, wait, and then enter the crosswalk along with other pedestrians when there clearly was a change in the traffic flow. And it very clearly showed she had the right of way, she had the green light, she was in the crosswalk, and that was a huge piece of evidence to get right away. The other thing we did right away is contact, I knew that I wanted to contact the 911 authorities. I sent a preservation letter to the police department and asked them to preserve the audio recordings and the log of everybody. That, I'll send a quick nod out to the AAJ trucking litigation group. That was something that I heard somebody talk about years ago when I first I was a younger lawyer and started handling truck cases, and somebody said a great source of potential witnesses can be not only the voice recordings, but the log of everybody who's called 911, because they will log all of those people. And so I asked them to preserve that, and we put the case into suit very promptly so that we could then serve a subpoena on the police department and get that information, which we did. We found some witnesses, a couple of healthcare workers from the hospital who remembered very well what the situation was. And we were also able to get the actual 911 tapes. So many people from the video, it was clear that people were just on their phones. And when we got the 911 tapes, it was clear how many people were calling 911.
Well, I don't want to, but when you say, because I always have this question that comes up, and it always is kind of a debate in my office, and I'm sure it is with Mike. You say you put the case into suit pretty quickly. That is, make that a little more concrete for us. How quickly? How do you make those decisions? Because I think most of us have a lot of cases to where we don't know, well, we're not going to file. We're just going to, let's see what's going on here, and then we'll file it if we can't get it resolved. Because you're dealing with catastrophic injuries here. So what was the thought process of let me file it right away versus, listen, these damages are enormous. I've already got the gold in the video. When is enough? Like talk us through that strategy decision-making.
Well, I knew right away that she was battling while she was still in the hospital. She was battling to save her leg. And there was active discussion about whether or not just to amputate her. So her left leg, and let me explain the mechanics of the injury. As she was walking, she got knocked down. Her right hip was fractured. And when it was an SUV, it was a commercial vehicle, but it was an SUV. When it backed over her, it crushed her left lower leg with a massive degloving injury. So they were not sure. They did a repair on the hip, but they weren't sure if they could save the left lower leg. And I'll talk about that a little bit later on, about the involvement of her physicians in the case. So I knew it was a big injury. There was even a question of whether, I know from the other work I do, she was at huge risk for an infection. She could get an infection. She's at an age where she's at risk for an infection. She could succumb to the infection. And I knew I had a client who was alive and with me at that time. And part of my decision was informed by my late partner, Dave Shrager, former ATLA, now AHA president. Dave was president of ATLA back in, I think, 1984 when I was a brand new lawyer. David always used to say, lawsuits talk. If you can talk until you're blue in the face to an insurance company, but lawsuits talk, and that's what they'll listen to. That's the language they know. So my bias is always they can settle a case just as easily once it's in suit as they could beforehand. And if they settle beforehand, they're looking to get a bargain. So the decision was quite easy for me. I had a client. I wanted to make sure the client was alive as long as possible, and I knew that this case was going to settle most favorably if they knew that we would and could try the case. And I wanted to get the case in line in Philadelphia County.
So weeks, days, months, how fast did you pop that thing into suit?
Within about a month and a half,
Gotcha.
I was in suit.
Okay.
Yeah. I wanted to make sure I had my ducks in a row, and I had to wait until I got the medical records because I wanted an accurate description of the injury to put into the complaint. So
at that point, she's just getting out of the hospital when you're filing.
Yeah, well, she got out of the hospital, went into a rehab facility, a skilled nursing and rehab facility. I can tell you that accident happened in early November 2019. She's never been back to her home since then. Wow. To live. She went to a skilled nursing and rehab for about 60 days after she got out of the hospital. And she's moved into an independent living, one-level facility, and she had nothing short of a spectacularly gorgeous old Philadelphia stone home. It makes you think of Philadelphia story kind of a home, and she's been back now for visits, but she hasn't spent a night there since.
This is a lady who seemed like she was very independent, very active before this all happened.
Oh, incredibly independent and active. She was one of the driving forces as a fundraiser for the hospital. Still at 86, she was raising huge amounts of money and was still courting one donor for an endowed professorship. When we're talking seven-figure gifts to this hospital, and she was the primary contact. So, and she worked for the hospital, believe it or not. She had been, when her husband was physician in chief, she had volunteered her time, but she really adopted this hospital as her family. And she, after her husband passed, they put her on payroll. as a development person. And she said, "Oh, I don't know what they pay me." I said, "Pay me whatever you think but she was working. She was still on payroll as an 86-year-old because the hospital valued her engagement so much. So this was really phenomenal. And let me tell you, when she went to the ER, some very senior people showed up in the ER and said, "Get this right."
Right.
And the team of physicians who showed up at the teaching hospital that was nearby was world class.
So when you got the 911 call logs and they came in and you were able to identify some witnesses, were you making those calls? Were you having your private investigator make those calls? Who was making those calls, and what's going on in that process?
I made those calls because I knew the facts of the accident so very well at that point. I didn't want to trust it to a PI, and I wanted to hear what these people had to say. What we also did, we had the video, and I pressed really hard to get the driver's deposition as quickly as I could. So for a November of 19 accident, I think I took the driver's deposition probably within 5 or 6 months of the accident.
As you're dealing with COVID restrictions and everything like that coming into place.
I did it just as we're talking now by Zoom. I took the driver's deposition and essentially obtained an admission to liability. And one thing I'm skipping, by the way, as we got into suit, I held the video that I had until I took the driver's deposition because I wanted to show it to him during his deposition, and we sent our discovery responses. And at one point, I was speaking with defense counsel, and he said the video, and I called my associate, called my paralegal, said, "Did anybody ever mention that we have video to defense counsel?" And they said no. So I called defense counsel back and said, "Hey, you mentioned a video. What are you talking about?" He said, "Oh, I thought we sent that to you." I said, "No, they had a dash cam video." So we had a view from the office building on the corner. They had a different angle view from the dash cam in the vehicle. So I actually, wanted to get a little bit creative here. And Mike, you'll appreciate this because part of your video team here is my son, who is
That's right.
Works in the film industry. So I sent him the 2 different feeds, and what he was able to put together was he put both feeds on the same screen and was able to time sync them from the moment of impact. And while the office building's security video had no sound, the dash cam had sound. And he got them running at the same speed. So we had 2 different views. We had a view of her walking down the street, and then there's the dash cam. As you can see, this full-size SUV pulling into the left lane, getting ready to turn, and then turning the corner and just hitting her. You hear her scream. You hear the thud, and it's one of those sounds that when you see and hear it on a video, you never forget it. I never let the family see the videos. Sure. I wouldn't. I just couldn't do that because, as you guys know, when you work with this sort of thing, that type of trauma in video it's burned into your brain once you see it. So my son, who is a wonderfully skilled film guy, put them both on the same screen, and then he ran them in slow motion, and that became a very effective piece of demonstrative evidence that really made it clear that she was absolutely visible, there to be seen from the driver's point of view, and the video I had gotten clearly established that she had a right of way and that she was there. So liability quickly faded away. The other thing we did as the case transitioned was to really try to develop the damages as best as possible.
And so what do you do? Because I'm thinking in my cynical mind that, well, I know she's active. I know she's a great lady. She's 86. A pneumonia could put her down. Shit, a COVID could put her down. This is not like she's 26 and almost lost her leg. I mean, no matter who you are, no matter where you're coming from, that has to be an obstacle that you're looking at is age. And even though she's active, how are you countering that? Like, is there a life care plan? What's the idea?
There were a lot of things we did. And this was a case that, because of the nature of the case, I think something that all of us do, you guys, before we went on the record, we're talking about a case you just tried together. When you live a case, you live it. And I had bi-weekly conferences with the family, just to tell them what had happened and just to keep them talking to me. And, among the things I learned from them, for example, she used to go to the gym every morning. She would drive herself over to the gym and she would get on a treadmill and she would just walk on the treadmill. And she said, well, that's my reading time. She would read on the treadmill for an hour every morning before she started her day. And so I knew that about her. And other people knew that about her. So we had that piece of information. We also, this is somebody who was going to the gym, was still working. And we had wage loss records for her to show that she was still working. She owned a vacation home on the Chesapeake and another at a place down in Florida, a condo, and she would travel regularly. She was still going everywhere she wanted to go. She would drive herself to the Chesapeake home whenever she wanted. So when I tell you that she was incredibly dynamic and independent, she would make some 60-year-olds jealous with her level of activity. And as she started to recover, and I talked to the family, the family mentioned to me one time, well, her orthopedist has some pictures of her left leg, the one that was crushed, from the day of the injury. And I promptly wrote to both the orthopedist and her plastic surgeon. Actually, it was a burn specialist who was called in. A burn specialist was called in for the degloving injury on her leg. And so I actually reached out to both of them early and said, listen, you represent my client. I'd like to borrow 15 to 30 minutes of your time just to talk about your involvement in her care, and let them know, they knew this case would go into litigation. And the orthopedist couldn't have been more helpful. He said, well, I have pictures, he said, but they're not in the medical record. I took them for academic purposes because nobody expected we were going to save this leg. And I said, I'll tell you what, I'm going to craft a specialized HIPAA authorization and have my client sign it so that you can release those photos to me. And they were photos of her left lower leg, really in the initial orthopedic consultation in the ER. And when I say it's a degloving injury, you can just see this ripped and shredded skin, muscle, tendon, and fractured bone just hanging from her lower leg. And it was as graphic an image as you could ever imagine. But he had these because he expected at some point, if he was able to preserve her leg, to write up the case as a case study. And I'll get to that in a little while. So I had those pictures. I had spoken to him. I also spoke to the plastic surgeon, but the orthopedist had said, and I'm remembering his words, he said, she's a force of nature. And I said, tell me what you mean. He said, she willed her recovery. Most patients would have given up and told me to take the leg. She said, I am going to walk again. And he said, she willed that leg to recover and did all the hard work that you would ever want a patient to do to make it happen. And that's why she still has her leg, and that's why she's able to walk now. And I said, look, at some point, I'm going to want to take your testimony and ask you to appear at trial. And in speaking with the burn specialist, world-renowned burn specialist at this hospital, and they deal with this kind of friable skin and lack of vascularized skin. It's very, very hard to get it to cover.
Yeah, this is 86-year-old skin. I mean, this isn't pliable skin.
It's like tissue paper in many ways. And it was up to him to try and close and cover the wounds so that the infection was not a risk for her. And he actually said that he used a material in this case that had never been approved for or ever described in the literature in this application to try and close it. And he told me that he planned to write the case up as well because of the use of this material they typically use in burn cases, and that it was effective in a complex trauma case. So I had two different university-based physicians who were incredibly supportive of what a horrendous injury this was, and what a remarkable recovery she'd made, and what her limitations were. And the orthopedist actually said, to explain, I mean, as time went on and the left lower leg healed, the pain that began to bother her was the right leg. And I spoke to the orthopedist. Again, the family would go to all the meetings with the doctor, and said, he said that the rod he put in doesn't fit, and that that's what she's feeling, pressing all the time. So I called the orthopedist back, and he said, well, she's very petite, and I used the smallest femoral rod that I could, but it still sticks up a bit at the top of the joint. So what she's feeling, and she will feel for the rest of her life, is this rod extending into the joint and creating the source of pain. So she'll have pain walking the rest of her life, and that's something we needed to do to stabilize the hip. And then he also explained that the hip, ideally when you repair a fractured hip, you want to get the people up and walking on the repair as quickly as possible. He said, I couldn't do that because of her left lower leg. She was incapable of bearing weight. So I was afraid that she would have too much muscle atrophy in the supporting muscular structure, and that she'd never get maximal rehab in the right hip. So the left leg slowed down the right hip healing. And then once the left leg finally caught up and healed, then the right hip had its own issues. And it was a remarkable story they both told. So when the defense finally asked us to mediate the case.
Yeah. What are their defense? Do they have any defenses?
We never got that far.
Okay. Gotcha.
I never saw a reconstructionist describe the case. And since the driver admitted at the end of his deposition, I played the video. I said, do you agree that she was directly in front of your SUV just before you hit her? Yes. I didn't see her. I'm so sorry. I didn't see her. It's my fault. It's all my fault, were his words. And I felt terrible for the guy.
Yeah. How do you handle, what's your strategy with him? He seems like a nice guy who made a horrible mistake.
He was a nice guy, a hardworking guy. He was an immigrant from one of the islands. He had sort of a lilting accent, but he was a family man, a homeowner, and just felt remarkably contrite and sorry for what had happened. And I thought to myself, I don't see a jury killing this guy.
Yeah.
For what happened here. He made a mistake. He's apologetic. He's owned it. And he said people were yelling at him, back up. And that's the only reason he backed up. And then I replayed that part of the video. And in fact, what people were yelling to him was stop. So his recollection was not quite consistent with the audio we had from his dash cam.
But you're not beating him up in the depot. I mean, what was your approach going in? You'd never met him before, obviously. And you just kind of gleaned when you got in there that he was going to be a sympathetic figure, or that you had kind of picked up that he was a nice guy and this wasn't going to be a drop dead, I'm going to box him to death deal. It's a nice one.
It was clear early on that he was owning what had happened.
Gotcha.
And, as I showed him the video, he was owning what had happened. And I said, I took him through the standard, some basic rules work. You're making a left-hand turn. You agree that you have to yield to pedestrians in the crosswalk. Yes. And you understand that in Pennsylvania, when a pedestrian is crossing the light and is in the crosswalk, the law requires you to see that person and to yield to that person. Yes. And when I realized that he's giving me the standard of care and agreeing with all the basic rules that I would ever need to try the case, you don't have to beat up on somebody like that. And especially, I knew his background, and I thought when a jury got a sense of how apologetic he was and how obviously broken up he was over this horrible injury, that he'd be a sympathetic defendant. And honestly, I didn't have that much against the corporation. When I say it's a commercial vehicle, it was on a commercial policy, but it's an SUV, and this is he was just sort of a a guy who would run between a couple of different locations for the company, and they had this SUV registered on a commercial policy. It wasn't a tractor trailer or a box truck or anything like that. So a lot of the things that we would use in a truck case didn't really apply here. And we didn't. And he had safety training courses, and he had a clean driving record. He'd never had any other accidents. When he began driving with the company, somebody actually rode along with him for quite a long time to make sure he was a safe driver. All of those things came out in his deposition. And, I made a sort of seat of the pants determination that, okay, there may be a corporate case here. And, the way I got the case to move at mediation was to start serving corporate representative, 30B6 notices to depose the safety director and things like that, and really push that issue a little bit more. But the other thing we did, we spent a lot of time getting ready for the mediation, and it created a fantastic, what I think was really a fantastic mediation video. And again, I worked with my son. I went out with our videographer we use from a local court reporting company. Sorry, I didn't call gavel for that, guys.
That's all good.
Maybe I could have. But I took a videographer I work with from a local court reporting and trial technology company, and I know they have a very high resolution camera that they use. That's one of the reasons I like working with them. And I went out and I did Zoom interviews of the orthopedist, the plastic surgery burn specialist, and the current physician in chief from the hospital with whom my client had been meeting until 5 minutes before the accident happened.
These are just interviews, not depositions, right? These are just
on the record interviews that were filmed by Zoom, actually. And, to give you an idea of how conscious and alert my client was, there was somebody bending over her while she was still under this SUV, and she hands the person her phone and she said, "Call Dr. X, who's the physician in chief." And this woman explained in this interview, in anticipation of the mediation, she said, she had just left my office and my phone is ringing. And well, I wondered whether it was a purse dial, but it's her. So I always answer when it's her. And I said, "Hi, what happened? You just left my office." "Oh, I've had an accident. I'm down at this intersection." And this head of the hospital went flying out of her office and ran down the street and got there to the scene. So I had her as one of our witnesses describing the blood, the portions of tissue that had been ripped off of my client's leg that were on the street, what the leg looked like and that sort of thing. And also
let me ask you,
I'm sorry, Chris.
No, I don't mean it, because I'm going through my head. I'm just thinking, Rob's doing a lot of work on this case, which it seems like most people wouldn't do that. They think, listen, this is pretty clear cut. Now I got this information, is that how you approach all your cases? Why were you like, hey, I need to get all this information? How many witnesses do you need that she got run over? You know what I mean? That's what I'm thinking. This is a lot of work going into this file.
I think it's the difference between a low 7-figure case and the level where this case actually resolved. I do enough nursing homework that I understand the biases against 86-year-olds. And I needed to show that this was one of Philadelphia's leading citizens, and that this wasn't just an injury to her, it was a loss for the whole city, that she had been incapacitated and the rest of her life is going to be limited in her ability to ambulate independently. And that, this was a life of one of Philadelphia's most charitably oriented and wonderful people, and it had come to a grinding, screeching stop. And this is a huge loss for all of us. And I think that takes that case to a different level from just an injury case. It's a loss for the city. And I wanted there to be no doubt that this really had to be among the strongest settlements of the year in Philadelphia. And so that's why I gave it that kind of attention.
Because it's a lot. I mean, you're doing a ton on, because I hear the case, I'm like, well, hell, Rob, it seems no need to go get the chief medical chief to talk about what she heard. I mean, you got people there, you got dash cam, but that is a good point. I think is a lot of us sometimes will think we got enough on damages. We have enough witnesses, and you're kind of saying, no. If you want to elevate this case into a different stratosphere, you need this entire picture of who the person is and what really went down. It just wasn't a lady hitting a crosswalk. There was a ton of crap going on right after it and what happened to her. I think that's a pretty solid takeaway for me personally. Selfishly, is like, shit, I need to look deeper into these things about who was there, what they did, why, what exactly happened, stuff like that. That's a big takeaway.
And, and frankly, I think the story that she had the presence of mind while she's still pinned under this SUV to hand her phone to somebody and say, call, here, this number, my most recent call her, she'll come down. And she did. This is a physician in chief at this hospital, dropped everything for this client and came running down to the scene. And I think that gave some idea of who she was and what role she plays in the city. The other, I'll be blunt. I mean, I found out early in litigation that there was a very substantial primary policy and an even more substantial excess policy, which in a commercial vehicle case is not at all unusual. So, our biggest fear when this case came in is that there'd be a limited insurance policy. Keep in mind, in Pennsylvania, you can be fully compliant with our liability insurance law if you have a $15,000 liability policy on your vehicle. In fact, in the city of Philadelphia, half the vehicles are uninsured, but still you can be, and they advertise that. Some of the bottom, I can say it in this context, bottom feeder insurance companies
I got full
advertise,
coverage.
minimum limits, minimum limits to fully insure your car. And it's been that way as long as I've been in practice. The Pennsylvania Motor Vehicle Financial Responsibility Law was passed in 1984. That's when I passed the bar. And so the minimum limits have been the same since 1984. And when I explain to clients how unreasonable that is, I say, tell me one other thing in your life that's still the same amount of dollars as it was in 1984. And nobody can understand why it stayed there. Other than the power of the insurance lobby. But this was a case with a very generous primary policy and an even more generous excess policy. So I knew we wanted to give them every excuse to settle this at full value in the middle of a pandemic. Now, understand, by the time we got the case into suit and I was taking the driver's deposition, the pandemic had hit, the courts were closed. We needed to give them every reason to understand that this case isn't getting any better if you delay it because of the pandemic. And that was sort of the other reason I really wanted to fully work up the damages, was to tell them, look, we're ready to go.
Push on the gas.
You can mediate and resolve this case for a full and fair value now, or you can wait for a jury. One final piece, I will say that absolutely we spent long hours in the office discussing, is a jury nullification piece. This was a woman from the suburbs who had led what many people hearing her life story would say was a charmed and very fortunate existence. Vacation home on Chesapeake, vacation condo in Florida.
Yeah, there's not an underdog. There's not in fact, the defendant has more of the underdog feel to him, and you're kind of worried about, we look for those in our cases, the plaintiffs, what is the underdog story, the rags to riches, but she seems to be fortunately very well off. So what would money do to help her, I guess, is kind of what you're thinking, or what's the...
And exactly. And, the one thing that, I wanted, the point I made to her, and the point I made to her adult children is, listen, your parents worked very hard to put together what they had. And your mother shouldn't have to deplete her personal resources to get the care she needs as the result of negligence of somebody else. What we're talking about here is making sure there's a fund available. So yes, you asked earlier, and I told you I'd come back to it. We absolutely had a life care planner. And at the time we had the life care planner, my client was able to leave the senior facility. The COVID rules had loosened by the spring. So her daughter was able to pick her up and bring her out to her house. And she sat and met with the life care planner at her home, and talked to and met the life care planner. And I showed the life care planner, all the access areas to the home have steps. She's going to need a ramp and that sort of thing. And she came up with, and I said to her, look, a jury isn't going to buy a Cadillac life care plan in this situation. What you need to come up with is something that, as reasonably as possible, will restore her lifestyle to her. She needs the independence to somebody who can drive her to her meetings, somebody who can assist her in the morning, assist her at night with the activities of daily living she can't do because of her limitations in movement, and very modest modifications. So she can at least, she said, all I really want to be able to do is host board meetings at my home again. So I don't think she's ever been back to the second floor of her house. She goes in and she exists on the first floor when she is visited. And so the life care planner got it, and took most of the medical bills had already been incurred, and she was at a point where there wasn't going to be a great deal more treatment other than yearly checkups and that sort of thing. But the supportive care was substantial. And this is again because she is somebody who had lived a life that took her to the family vacation home on the Chesapeake, and at Christmas and New Year's to a place in Florida, during the season down there. And the family would typically gather down there for the holidays. I said, let's build in an assistant to help her travel and to be with her there and perform the activities of daily living on vacation, so she can still spend the family time with her children and grandchildren that she enjoyed before. So we included those items, and it was a significant life care plan. But
was it a 7-figure plan?
Oh, absolutely.
Well, okay,
absolutely.
gotcha.
Yeah. But it was not an overreach. It was not. I'd seen overreach life care plans, and I intentionally encouraged the life care planner to not make it an overreach plan.
And that's like kind of a practice point I wanted to explore with you. Is I think some of us, and I've made this mistake, is you just get the life care planner, send your client over there, get the records there in advance, and then let them come up with whatever, and then just deal with the plan or use the plan that they give you. Where, is that a common practice of yours, is to talk more with the life care planner on the front end about what you're looking for and why? Or is that something that was specific to this case? Kind of give us a little bit more on talking to life care planners, and did you use an MD or a nurse? How'd you do that? Stuff like that.
I used a nurse, and I spoke extensively with her beforehand, and clued her into the issue that we were deeply concerned about, that we didn't want to find a situation where our client would be viewed as, these are, rich people's problems, by the jury. And, you touched on it a minute ago, Chris, in terms of the underdog comments you made. This fella was an immigrant, had gotten a good job, was a homeowner, was raising kids, and, he was sort of the immigrant success story, and was somebody that a jury that we might view as a good Philadelphia jury would be able to, wrap their arms around his life story much, much more easily than my client's story. So I didn't want to provide fuel to the fire in that regard. I wanted it to be totally reasonable, because I planned on arguing at some point to the jury that this was one of Philadelphia's leading citizens. All we're trying to do is support her in that role as one of Philadelphia's leading citizens, not give her the glam life. This was just, she needs transportation to get to her meetings. 2 days a week, she wants to go out to lunch with people. And she was doing fundraising lunches and dinners, many days of the week, even at 86. But we wanted to give her the support so she could continue in that role. And it was important for her mental health as well. She'd been very depressed by the injury initially, and she really needed to know that she could continue to make the world a better place. And that was a very deeply held belief of hers that she talked about. So when I did the settlement video, I actually went out to her house and filmed her in person with the videographer. So we had her in person, her two treating surgeons by Zoom, and the physician in chief by Zoom, interspersed with the video that we had, the double video and clips from that. And it ran about 17 minutes in total, which is, for a mediation video was about as long as I wanted it to go. So to give everybody, including the people who had to make the decisions, the best chance to understand what the case was about.
And so I would just want to explore one thing with you, because you do med mal cases and you know what it's like for a defense to hide behind the defendant, right? And so then you kind of look to, okay, well, are there some warts with the corporation? Are there some pulls here where they didn't follow safety rules where I can point at the corporation? It sounds like maybe there wasn't that here. So I know you got to be thinking about your opening or your closing statement and talking with the jury about how they're going to hold this person or this corporation responsible. And I think you said something about maybe deposing the safety director. What was your feeling on that? What was your strategy on that? And what were you thinking you could explore in like an opening or closing from that perspective?
I wasn't sure what I was going to get from that, because again, this is not a traditional transportation-based commercial company case. A truck company where they have hundreds of power units and they're logging millions of miles a year. If they're not doing safety training, I think it's real easy to get a jury very, very angry at them. This was a company whose corporate purpose was entirely unrelated, and they just needed this vehicle to get, if they were taking some things from one location to the next. It was a large, successful corporation, but it had nothing to do with transportation as a core business of theirs. So I just didn't think I was going to score those points. Plus, I had the driver's candid admissions already on video. One of the things as we approached mediation that I was very, very concerned about, and actually from the time I got the dash cam, I tried hard to understand how they defend the case, and I fully expected that at some point I would see a human factors expert report from the defense, because as it turns out from the dash cam, well, I knew that she was standing next to two other pedestrians and then stepped onto the road at the same time they did when the light turned green.
You're looking for conspicuousness or conspicuity, or what's the?
It's a little more subtle than that.
Okay.
From the dash cam, I knew that she was a slower walker than those other two, and that they had sort of walked across the street ahead of her, and she was still crossing behind them. From the dash cam, what really became clear, as I said before when I was talking about the hip rod, she was a very petite woman. What I think, if I had to defend this case, what I think happened is she was so petite that she was screened by the two bigger pedestrians. As they got ahead of her across the street, the driver couldn't see her behind them. And he assumed, so he knew people were crossing. He waited for what he saw was the movement, which were the two people crossing. He waited for them to clear, and his gaze was somewhere else, and knew that they had cleared his range of vision peripherally, and didn't then focus on the fact that at some point she became visible behind them as he was making his turn.
Busy Philadelphia street, you got oncoming traffic, you got people over here, you got honking, you got things going on. And so this guy's, doing his best, and he turns left. Were you hoping that they would try to raise that defense just so you could score some points on? Okay. I just had to ask,
I was going to say, the way you were describing it made me nervous too. I'm like, yeah, that could kind of make sense. She just was moving slower, and you're just moving with traffic, and it happens.
And that, in the end, he still missed her visually, but we've done, I've handled conspicuity cases where, there's a classic video that a human factors expert out of Canada that I've used has introduced me to, and it's somebody who's changing like his shirt color, and he's changing a lot of things while doing a trick with cards. And you're so focused on the cards that you miss the fact that his shirt color is changing during the thing. And you see there's a difference between seeing and perceiving. And, he could see her, but he didn't perceive her. And once he saw the other two pedestrians in front of her, my huge fear about this case is that a jury would be much more forgiving than I ever would have liked them to be. She was moving slowly or more slowly across the street. The other two people essentially screened her. The fact is, I'm sure he still would have gotten a verdict, but I think the amount of the verdict would have included some forgiveness of, oh my, that could have happened to me. Kind of a thing from the jury, which is part of the reason in the end when I said to the family, I think this is, we're going to do better at settling this case now than if they prepare this case for trial, because they will find a human factors person to totally analyze this, and they'll come up with some sort of a credible sounding excuse, whether if it's the one that I verbalized or not. They'll have it at some point, and we did not see that at mediation. So I think by pushing the case to mediation when we did, before any of the they had my experts. I was candid about the report I had reports from the two surgeons, and so they had that, and they knew that we had an admission as to liability. I don't know yet whether or not they had an expert looking at this case from that perspective, but I had something very funny happen about 6 months after I resolved the case. My wife went to a CLE. Actually, I think she might have even been speaking at the CLE. My wife's an attorney as well, and she emailed me. She said, "You've got to contact this one experts company that provides a lot of accident reconstructions in Philadelphia, actually around the country. You've got to talk to the guy who heads that company, because he talked about a video where he had gotten video from the scene." And she said, "Rob, it's the video from inside that office building from your case." And I said, "Really?" I said, "That's fascinating. So maybe that video got sent by the defendant." So I reached out to this guy. I've retained him many times. In fact, in trucking cases, I often call him as soon as I get the case, just to get him aboard and make sure the defense isn't going to hire him. And he sent me his video. Turns out he had another intersectional pedestrian versus commercial vehicle collision at that intersection, and it was a delivery service truck coming from the crossing street, turning onto Walnut Street, not turning from Walnut onto the crossing street. So it was, and my wife didn't know that. And when I looked at it and realized, oh man, it's another case. And in that case, he was retained by the defendant, who had found that office video as well. But what he did is they went out and they laser scanned the whole area, and they were able to reconstruct the angles from the laser scan in a way that, and let them present a story that was very favorable to the defendant driver. And I, what I saw afterwards just confirmed for me that we were absolutely right to press that case.
Well, and it speaks
as soon as we did.
Putting the gas on and showing them that, I think the quick filing is a big, like when you have a damages case that's solid, you keep the pedal down. I don't know if this is true or not, but my suspicion has been that when the defense gets a quick filing on a big damages case, no matter who it is on the other side, they're like, hell, these guys are moving fast. They are on top of this. They're already ahead of us. We're going to be playing some catch up. And it doesn't seem like they're ever going to let up. We might as well not spend a bunch of money now and still pay a bunch of money. Let's try and figure if we can get this done early. I mean, is that kind of the suspicion you had? Have you talked to the defense lawyer off record afterwards, or what was the feeling?
I did not talk to him. He was one of those people that you really love having as your opponent. He was kind and polite to my client. My client made it clear he was so nice. What a nice young man. The guy's my age, what a nice young man. He was really so nice. Listen, remember, he's not your friend. If he's doing his job, he's going to be minimizing your recovery. But he actually, too much to his credit, honestly, he's one of those people who fully understood the damages, fully understood the case, and in some ways is the type of older school lawyer that I was trained by, and I'd like to think those of us who've been practicing 37 years now, you know, can still sometimes view a case and look at it and say, you know what, we need to do the right thing here. Let's get the information. You know, I gave him all the time he needed to prepare his case, learn what the case was about, take my client's deposition, you know, do all the things he needed to do to obtain the information he needed. But at the same time, when I said, look, you know, this is a case that it's not going to get any better. Her life is going to be, it's going to be a longer period of time paying for her independent living, which is a very expensive residential option. So the economic specials will continue to mount in this case at it's between $5,000 and $10,000 a month, you know, for that kind of living facility, plus the additional private duty care that she's paying for. So you're looking at, you know, easily $10,000 to $15,000 at least per month, just because she can't go back and live independently in her home now. So this case isn't going to get any better from an economic specialist perspective. And that often, I think, is the best argument we ever have, that the economic specials will continue to mount at a rapid pace and so the case is going to be harder and harder for them to resolve if they don't do it soon.
Sure.
Because you're doing two cases, really. You're developing your trial case, which is going to be a lot of non-economics, but you're also trying to get the defense lawyer everything he needs, because they don't, you know, let's be honest, they don't really value non-economics the same way that we see juries do it. So you're feeding that case to them as well on kind of the two tracks, I guess, to kind of make sure you're covering all your bases to give him everything he needs.
You said it exactly, two tracks. And I'm going to invoke the name Dave Shrager again, my late partner. Anybody who goes to AHA at the annual meeting, there's a discretionary award that the president can give out that is named in David's honor, the Shrager Award, and that the president, the outgoing president can give at the end of their term. David used to say a couple of things about that. And when you talk about two tracks, David made the point that we proceed on two tracks like railroad tracks. They're both leading to the same goal, but one you can view as a settlement track and one as a trial track. And a train, when it goes forward, is at the same place on both tracks, but it's complete trial preparation that drives full and fair settlements. And the only way to get a full and fair settlement is when they know we can, will, and are fully prepared to try this case. So they saw my demonstrative evidence. They knew we had the cooperation of her treating surgeons, and that was going to be very favorable testimony in a Philadelphia case from these, you know, leaders in the medical profession in Philadelphia. So they knew that. The other thing you said, and another Shragerism that, you know, has continued to inform my practice ever since I was a 10-year lawyer and started working for Dave before I became his partner even. And that was, you have to give every defense lawyer a fair opportunity to work his case up, because the only way he'll understand how to make a full and fair recommendation to the insurance company is if he understands the case. So he said, you can have the clearest liability case and don't get angry at a defense lawyer for doing his job. He needs to understand the case if he's going to become your partner in getting the case resolved. And that was a fascinating perspective, that we don't view them as our partner, but is somebody that we have an unwilling handshake with. And that's defense counsel, because no case is going to settle unless the first thing they do in their report letter to the insurance company is give an estimate of potential jury verdict value and the range within which the case can be settled that is an appropriate estimate and range. If they lowball the case, you'll never get your case settled, because the insurance company is going to rely on that. So we need to sort of, to some extent, be open-minded to pumping the information out there and making sure that the way we believe in our case, our opponent comes to believe in the case and understand the risk.
That is, you hit it on the head. Fascinating. That's exactly what I thought too. It's a fascinating perspective. So some quick takeaways: get in the case early, get your investigation going early, develop those non-economic case stories early while the witnesses can still remember your lady walking on, the treadmill at the gym. and reading her book. Those are important. And then the economics, developing those as quickly as possible, get to know the doctors, get to know the.
Yeah. And absolutely. And one last point, I can't understate the value of. My client did pretty well in her deposition, but when I put her on video sitting in her own living room, and I asked her in her deposition, they didn't really get into her background, but when I asked her on the video for the mediation memo, the video memo, to tell me a little bit about her upbringing, what became clear was what a deeply religious woman she is, and how her father had instilled in her from the time she was a very young girl, that the only thing you can be judged on in life is whether you leave this world a better place. And she said, I've dedicated my life to working hard to make this place, to make this world a better place, which I thought went a long way to overcome the suburban wealthy widow dynamic that I was very concerned about, because first of all, her religious commitment was beyond dispute. Part of the damage is, she said one of the things she misses is she used to walk to church winter, spring, summer, and fall, the mile over from where she lived outside of the city, across the city line, to her church that she attended. And she said, I miss that. I miss being able to walk to church. It would clear my mind before I went to church, and I could always reflect on the service on my way home. I miss that very, very much. I think that helped. So she was, obviously, it's pretty clear I adore her. Yeah. I was really very fond of this woman, and got very close with her in the course of the case. And that's, some lawyers keep their clients at arm's length. I embrace mine, and I have incredibly warm feelings for her. And it was just such a pleasure to be able to help our system that we all work in do the very, very best and most proper thing for her, so that she'll be well taken care of the rest of her life. There's no doubt. Awesome. And she can do what she wants. She has the ability to do what she wants now.
Well, that's outstanding. And to close out, we were out there in February of 20, and I remember going around everywhere, and it became clear that Rob is the king of Philadelphia. Everybody knows Rob. He's got all the angles, but not just that, he cares about his clients. So if you're listening to this and you're not convinced, which I know that you will be, if you've got something you need someone to handle in Pennsylvania, Rob's your guy. And Rob, thank you so much for coming on and talking about this case. We really appreciate it.
Mike, Chris, thank you guys for having me. And if I didn't tell you when you were here, Mike, it's my wife, who is from the northeast part of Pennsylvania, always jokes that if you bump into somebody and you're with my husband, you can tell when they knew him from, because if they knew him from high school or after, they call him Rob. But if they call him Robbie, and there are still plenty of people who call me Robbie, then she said, you knew him from junior high school or earlier. And so that's awesome. It's a hard, fast break. I went to high school and I wasn't Robbie anymore.
Yeah, sure. Absolutely. Thank you again, Rob.
Thank you, guys. It's a pleasure.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. Here's your hosts, Mike Campbell and Chris Finney.
Man, that guy, wealth of knowledge.
I mean, the level of detail he was going into when I was asking, because let's be honest, that case that he was talking about seemed like a kind of a clear liability case. But the things he was talking about, you have to be prepared for anything when you're talking about, millions and millions of dollars.
That's right.
Just the way it is. And also, that lady was an older lady. To get value like that for somebody, you usually get the argument, oh, they're so old. That shows he was way ahead of the game.
Not only old, but also independently wealthy.
Yeah.
What is money gonna do to help her? And that aspect of them having a sympathetic company, a sympathetic driver. And, it's a tough, people get these cases in, they think, man.
There's no easy case. There's no slam dunks. There really isn't.
And you got to see the angles. and know the traps. And if you don't know them, then you get in touch with a guy like Rob Sachs to walk you through it.
Well, and that's the thing is like, if you know them or you're working with somebody who does, you can get out ahead of them and they don't become an issue. It's when you don't know them, they become a huge pain. And those are some of the things like, as we were going through this, like, well, Rob's doing all these things. Why is he doing? Well, he's getting ahead of everything, so it doesn't become an issue for him. And that way you get a clean resolution of the case. So it's very, very good reminders, learning for me and hopefully everybody else. Yep.
Well, we've got more trials coming up, more work to do, and hopefully a couple more of these podcasts in between.
Yep, absolutely.
All right, brother. Good talking with you.
Likewise.
That concludes another episode of Case Autopsy, the Verdict and Settlement Podcast. Part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.